everyone joining us for the launch of the Oxford Commentary on the 1970 UNESCO and 1995 UNIDROIT Conventions on Stolen or Illegally Transferred Cultural Property, which was published last year in 2024 by Oxford University Press. I'm Alessandro Chechi, one of the editors of this volume. The other editors are Anna Filippa Verdoliak and Andrei Jakubowski. Andrei is here with us today. Instead, Anna could not make it as she's based in Australia and it's night now. This afternoon, I will speak on their behalf as well. I extend my warmest welcome to our esteemed panelists, Professor Clémentine Bory, Professor Bert de Marsan, Dr. Zeynep Boz. They are the authors of some of the chapters of the commentary. I'm grateful that they accepted our invitation to speak at this webinar at this busy time of the year. Finally, I would like to congratulate the other experts who contributed to the book, some of whom may join us today. This webinar provides an opportunity to critically examine some of the legal aspects of the efforts that have been made in Europe to tackle the illicit trade in cultural objects. So our panelists will not just discuss their individual chapters, rather they will explain why the 1970 and 1995 conventions remain highly relevant today in the fight against the illicit trade in cultural objects. One reason is certainly the persistence of illicit trafficking, as demonstrated by statistics published by law enforcement agencies. I won't cite figures here. Instead, I would like to recall the ancient artifacts stolen in a Dutch museum last month and the restitution of cultural relics to Iraq in the past weeks by Italy and Switzerland. Moreover, our panelists, I'm sure, will emphasize that our commentary is a valuable product for understanding some of the strengths and weaknesses of the 1970 UNESCO Convention and the 1995 UNIDROIT Convention. More importantly, they will stress that our commentary is a useful resource in understanding how the provisions of these treaties should be interpreted and applied. Before giving the floor to our panelists, I would like to say three more things. The first is that the first chapter of the book, the introduction by Anna Verdoliak, is now available in open access on the OUP website, and I'm sure that Andrei has already put the web link, the direct link in the chat. The second thing is that you can buy the commentary with a 30% discount. You can get this via the QR code that is now or very soon available in the chat. And third, I would like to stress what is, in my view, one of the added values of the commentary that we are celebrating today. In addition to the fact that it covers all relevant legal, judicial, and policy developments up until the time of publication, besides the fact that the authors of individual chapters are leading scholars in the field from all 5 continents, well, I believe that the real added value is that the commentators made an extensive use of the travaux préparatoires. I'm aware that some authors even interviewed negotiators of the 1995 UNIDROIT Convention to gain first-hand information. Perhaps this aspect will be emphasized by our panelists, or maybe will come up during the Q&A session that will follow the last intervention. So stay with us until the end if you have questions or comments. Now the time has come to introduce the first panelist. Please forgive me, I will avoid reading long bibliographical summaries. So it's my pleasure to give the floor to Professor Clémentine Bory, Professor of International Law at Toulouse Capitol University. She will focus on the second part of the commentary, the one about the 1970 UNESCO Convention. Clementine, you have the floor.
Thank you very much, Alessandro. May I just begin my intervention by saying how impressive is to me the commentary of the both conventions, because I think it has been, as Alessandro said, it's a very huge work for every author, but also for the three coordinators, which I also want to thank. I'm sure so that it will be a very useful tool for states, for practitioners, and for academics. And today I wanted to focus maybe on two aspects. The first one would be the importance of the convention, the 1970 convention, and of the commentary nowadays, I think, in the fight against illicit trafficking of cultural goods. And second, I would like to mention maybe some matters of concern for the future, which may be raised in the commentary, but I want to address specifically because I think we should talk about this in the short term. So firstly, why is the 1970 convention still very important, and why is the commentary, I think, very important in this regard? First of all, I think that we have to mention that the principles of the convention have become widespread. The convention is 55 years old, and its principles have been going everywhere in law, in international law, but also I think in European law, be it national law or regional law. And I think it's something important to mention. Among the 147 state parties to the convention, 28 can be counted as Europeans, which is a lot. And I think that one case law, which is recent from the 2nd of May 2024, is interesting to mention. This is the Polghetti Trust against Italy case before the European Court of Human Rights. Because here we see that the European Court is taking the convention as a normative standard for international law, saying that the convention takes ground and gives importance to the wide margin of appreciations of states to determine what is part of their own cultural heritage. And this enables the court to say that Italy is right to ask for the restitution of the Atleta di Fano, which means that, as the European Court states it in its paragraph 340, the protection of a country's cultural and artistic heritage is now a legitimate aim for the purpose also of the European Convention. So it enables to restrict the right to property and enables the states to take some confiscatory measures. I think this is really relevant to understand the importance of the convention today, also apart from the convention system itself. The European Court of Human Rights is not maybe the only institution which is following the rationales of the Convention of Paris. We can also mention, I think, the Security Council of the United Nations. For instance, just to take one quick example, during the occupation of Iraq by American and British armies in 2003, the Security Council has been mentioning the importance of fighting against trafficking. And then in 2015, it reassesses the principle of its first resolution, saying in resolution 2199, that it decides that all member states of the United Nations should take appropriate steps to prevent the trade in Iraq and Syrian cultural properties and other items which have been removed from Iraq and from Syria, including prohibiting cross-border trade in such items, which means that the principles of the convention now exist everywhere in international and European law. The European Union itself is also following the principles and the rationales of the convention. When you think about it, the main trends of European Union law tend to resemble a lot to to those of the 1970 Convention. We can, I think, identify an intellectual diffusion of the principles of the Convention. The European law tends to consider European heritages as a national and regional heritage to prevent it from unwanted exportations. And as such, it follows the same logics as those of the Paris Convention. If we look, for instance, at the 1993 directive. The European Union also prevents cultural goods qualified as national treasures to be exported. This is the 1992 Council regulation and the 2008 regulation. The European Union also organizes the return of cultural objects which have been unlawfully removed from the territory of one member state. This is the 2014 directive. And nowadays, we see also that the European Union law aims at protecting foreign national heritages with the 2009 regulation on introduction and import of cultural goods. So I think that the convention is really important, and to read the commentary is really important also to study other fields, other kind of institutions in international and European law. Maybe the main challenge regarding the convention, which is widespread, if we want to it to be more successful again, is to work on implementation. And this is, I think, a huge challenge. For instance, I personally wrote the commentary of Article 12 of this convention, which Article 12 can be considered like a colonial clause. And it became, in fact, with a time, an international administration clause against illicit export, import, and transfer of ownership of cultural properties from other overseas territories. I hope that the commentary in that respect provides an in-depth understanding of the reasons for this clause, looking carefully, as Alessandro Checchi said it, to the preparatory work of the convention. And therefore, it sheds light on the initial ambitions of this clause, which were precisely not to bypass the colonial system, but to try to protect local and national cultures. And in fact, this article has been adopted under the non-aligned movement pressure on international law. It is the one figure was very important. It was the Mexican experts, which was underlining that dependency was creating a risk of cultural impoverishment that we still see today, and it's still a matter of concern. But nowadays, we see that the number of territories which are concerned by this article is low, which is a matter of concern regarding the implementation of the convention. Despite their conventional duties, the state parties often did not even create a specific legal framework to protect the territory's heritages. And strikingly, for instance, as we are all talking about this territory, we can notice today that Denmark Act of 2010 says precisely that the convention shall not apply to Greenland. So the heritage of Greenland is not included in the convention because of Danish reservation here. We can notice maybe that some kind of evolution seems to appear, which remain really shy. For instance, there is at the time a French project for a law to restitute human remains to the French overseas territories for funeral purposes, those territories being former colonies, which decided to stay within the French territory, which is the French states. There have been a first law in December 2023 regarding human remains and international restitution, and now there is this project to prepare a specific legislation regarding overseas territory. But anyway, in a word, the case of territories with a special legal status sheds light on the difficulties of implementing the convention and maybe of modernizing it, because the colonial clause cannot be seen as a colonial clause anymore, for instance. So this drives me to the second series of remarks that I wanted to make today, which deal with the convention's future. What may be the failures and the challenges for the future of the convention? I think it's important today, as the convention is 55 years old now, to shed light on some difficulties and matters of concern. And I wanted in particular to mention two aspects. The first one would deal with the rise of new actors and subjects of international law, which may not be included in the convention, and which drive us to the question of how can we try to deal with that actors. And the second aspect will be short. It's about other kinds of pieces of cultural heritage which may not be movables. What do we do with them? So first point regarding the non-state actors and the 1970 convention. We can see, and this is a matter of concern also in the commentary, that the Convention of Paris does not provide in itself maybe enough answers to the development of and the rise of new cultural actors. First of all, museums. And actually, the convention has totally changed the situation for museums, maybe not directly, but in fact, morally and to a certain point, legally. One must notice, and this is written also in the commentary, that the presence of the museums in the convention has almost been incidental. Syria has been suggesting at the very last minute that museums should be included in the convention. But before that, the ones which were supposed to be mentioned in the convention were the actors of the art market, which was very different. And in practice, the convention has proved to be a very powerful instrument to push states to create a legal status for museums and to push the museums themselves to create and to change their policy. So it has had a very important practical impact for the museums. But today, museums' regulatory needs are not all covered by the conventions. There are a lot of issues and matters of concern. For instance, museums' lack of means to implement correctly the convention. And this is something, it's written also in the commentary, that the UK delegation had already been saying from the very beginning, from the preparatory works, that this would be an issue. For instance, when museums once are today trying to make a lot of researches on the origins of their collections, where they are not helped, they are lacking the necessary means, which are not sought about by the convention. Maybe they would also need more precise rules. For instance, this would imply to make the difference between many kinds of museums, some of them being private, others being public. And you know that in international law, it's not possible to address the museums the same way if they are public actors, depending on the state, or if they are private actors. So it's difficult to create a legal regime with so little words as there are in the convention. So maybe we can wonder whether it would be opportune to create a new protocol regarding museums and maybe say a little bit more about them. Quickly, art market actors have been mentioned initially in the preparatory works, but no, there is nothing about them. And you know that they're a key actor of trafficking, obviously. They are only concerned today by soft law instruments like the UNESCO International Code of Ethics. Some tool, of course, may be helpful to them to fulfill the convention's purposes, like the Register of National Legislation, the databases that have been created, but don't we need more for them to respect the convention? Same kind of concerns regarding the cultural groups, among which the indigenous people. Obviously, those kind of issues and groups were not discussed in 1970. We only have the modern clause, which was Article 12 I mentioned before. So we need maybe something new, kind of protocol or some kind of mechanisms to help them recover their heritage, which is not possible through the lenses of the 1970 Convention directly. And among the novelties that the Convention regime should address, there is also the new kind of pieces of cultural heritage which should be considered. Just to say that a museum can also be in charge of intangible heritage, for instance. And we know that cultural heritage law has undergone a swift in perspective, going from tangible, only tangible, to also intangible heritage. So do we need something which would be similar to the 1970 Convention, but regarding the intangible heritage to address, for instance, the issue of cultural appropriation? This should be maybe a little bit useful. So I just need one more sentence to conclude.
Please.
Just to say, I finished by my main matter of concern, maybe for a Q&A, would be, do we need to frame a complementary regime, and how? What kind of method would we use? I'm sorry if I've been a little bit too long. Thank you.
No, please, no. Of
No
course,
worries.
there are two more panelists. Thank you a lot for giving this overview. Very interesting. But you put so much flesh on the fire. So probably many arguments that can be taken for the Q&A. For instance, the what you said about the chapter that you focused on, can these be used today by the museums and states to respond to claims coming from former colonial countries? Yeah, a lot of interesting points you raised. Let's use them for the Q&A. Now it's time to introduce Professor Bert de Marsan. He's professor at the Faculty of Law and Criminology at the University of Leuven. His intervention will be about part 3 of the commentary, which is about the 1995 UNIDROIT Convention. Bert, the floor is yours. Thank you.
Alessandro, and thank you for having me. Dear audience, I'm happy to speak today about the UNIDROIT Convention and the commentary that has been produced, that I had the pleasure to work on myself and already to consult the book. I will come to that in a minute. But first of all, for those who are not so familiar with the convention, we will celebrate this year, on June 24, 2025, we will celebrate 30 years of the anniversary of the UNIDROIT Convention, and it's a big date, and so it's also a good time to sort of make a balance. Where are we with this convention? Well, the convention was attended at the conference by a lot of states, actually 78 states, 8 as observers, also intergovernmental organizations like the EU, the Council of Europe, UNESCO. It's really indeed also closely linked, obviously, to the UNESCO Convention that has been debated just a couple of minutes ago. So a very important and very complementary convention to if you look at it, what it actually does. It adds. It is often said a private law part to whereas the focus point of the UNESCO Convention is rather public law oriented. But this being said, ladies and gentlemen, I will first discuss how what has been discussed and how the authors went about, what are the key provisions, and then I will move on towards the strengths and of obviously of the book, and then later on. Well, let's comment a bit on this convention, because the convention, as I say, will celebrate its 30 years of existence, and it's a good time to make a balance of what it has achieved under the regime or what influence it has had. Finally, I will also look towards the future, and that is something I would like to launch towards as topics for debate and discussion, because this convention is 30 years old, and we have to think also about the future, the trends that are going on, and that is precisely what I would like to do in this second part of my presentation. So let me first of all say that every aspect of the convention has been discussed. There is the preamble, and the 9 recitals as well have been closely examined and discussed. So, and what is really fascinating, if you read the book, if you read the chapters, you can see the inspiration or the travaux préparatoires, how they came about, what the central ideas actually are, because I think the author really tried to offer an added greater insight in the preamble. The preamble which actually came about in the course of the convention, in the course of the conference. I'm sorry. So that is a really interesting document, and it's also part of the convention, obviously, that is discussed. And then later on, there are 21 articles divided over the 5 chapters, if you're a bit familiar with the UNIDROIT Convention. And obviously, there is one annex, which is important for the material scope of application. I move on just to say, briefly flag the first chapter dealing with the scope of application and definitions. Very important articles. These are key articles, and they are really extensively debated, extensively analyzed from all angles, because they are so important. The scope of application and the definition of the cultural object for anybody who will be working on the UNIDROIT Convention. What the book is offering here is really a very useful instrument. I will get to that towards the end, when I make a balance of what are all the aspects that the book really brings us as scholars and people working with these conventions, what we can gain from it. I move on to the second chapter, really innovative in a certain way, just highlighting that one of the great added values of the UNIDROIT Convention is that it also dealt with the restitution, and the terminology is important. The term restitution is linked to stolen cultural objects, and so that pillar, so to say, is developed in the second chapter. Again, both articles, Article 3 and 4, are debated, and every important element is really discussed. At the principle of restitution in Article 3, explaining what the cultural objects are regarded stolen, and also unlawful excavation is an important element there, and also a very important thing to stress in comparison to the UNESCO conference. Also, the time limitation is very important. There are very important provisions there, and very meticulously analyzed by the author there. Also, Article 4 regarding the matter of compensation for the possessor. The principle of restitution is, so to speak, vested by Article 3, and that is in to somehow favor the source countries. But it's the convention is time and again a convention about balancing the interests. And then Article 4 comes in regarding the matter of compensation and all relevant elements. Again, the due diligence, the regarding the liability of prior transferors, the recourse against other persons, the defining the due diligence, because here a very important merit of the convention is that it really shifted the approach, and that there was the due diligence had to be proved, had to be proven by the burden of proof shifted to the purchaser, the duty to inquire, which is one of the novelties of this particular convention, the UNIDROIT Convention. I move on to the third chapter, and which somehow mirrors the structure of the previous one. Again, the principle of return is a central concept, is vested in Article 5, and then Article 6 is the one regarding the matter of compensation for the possessor. And again, the relevant elements, every issue that comes up in discussion in case law is really well tackled. Article 7, to conclude the chapter, is about the excluded situations, which is also really relevant. The illicit export that became legal due to changed regulation, it's an important issue in practice. Also, the fact that living artists or artists with recent careers that they still have the possibility of seeing their work circulated on the market. Fourth chapter, Articles 8, 9, and 10, which are called the general provisions, are rather technical, and which also justifies that quite some attention is given to these articles, because we are dealing here with scope of application ratione temporis in Article 10, only objects stolen and exported illicitly after the entry of the into force. So time-wise, very important article. Article 9 regarding the application of rules more favorable to restitution, another technical issue, which regime will be applied. And then Article 8, the competent authorities to decide or hear the cases, which are really crucial, actually, to bring your claim or to have your claim heard. And then finally, before going into a more general discussion, I will just briefly flag that there is a fifth chapter, which is actually quite extensive, from 11 to 21. But all of these provisions are called the final provisions. But I keep on stressing time and again, although they are not, so to speak, the material or the substantive part of the convention, that they do not bring about the regime of restitution or return and compensation, which we just saw in chapters 2 and 3, but they are important. And I keep on stressing that also when I teach my students about the UNIDROIT Convention. If you look at the list of states that joined, I mean, you have to pay attention to the declarations they made. You have to understand the mechanism of the denunciation, the reservations, the declarations that are made, how the ratification, acceptance, approval, and accession works. All of these, let's say, treaty-making related aspects are thoroughly tackled by the author. And so, as a result of all of that, I can say that we have in front of us a book that is extremely detailed, a commentary of about 21 articles in over, I mean, more or less 250 pages, really focusing article by article on what is there in the convention. For each article, an introduction. There is a lot, and that has already been stressed in the introduction, a lot of drafting history that allows us who work with these conventions to understand, because I already stressed the fact that the convention is a sort of an equilibrium had to be found, a balance had to be struck between a number of, let's say, competing interests. On the one hand, civil law, on the other hand, common law. On the one hand, market, on the other hand, source countries. And it's really enthralling and fascinating to see what delegations made, what observations made, what remarks made, what proposal. And here all authors made sure to meticulously go through these preparatory works. And that, to me, really is one of the strengths of these books, this book, and one of the great added value. It is very rich in sources, also by bibliographic, and you will also find, I mean, good articles, literature that discuss the strengths, but also the weaknesses of the articles. And obviously, it's an actual commentary dealing with elucidating the terms, the provisions, the mechanism, adding a lot of case law where possible, where relevant, and also coming up with a number of critical notes on the side, reflections, depending on the author. But some of them really go quite some lengths in there and really voice their critical thoughts as well. every article has a nice introduction to sort of set the scene, and there is a nice conclusion that also brings it together and puts it in a broader perspective. Some of the merits and achievements of the UNIDROIT Convention. So I spoke about the book. Now let's again focus on the UNIDROIT Convention. I mean, it really made, it's undeniable that it made an actual contribution to the protection of cultural goods. It made an undeniable contribution because it influenced in case law, but that obviously also had an impact on EU law. It had an impact on national law. I just sort of testimony from my own home country. I come from Belgium, from Flanders, and I was only very recently asked to work on the heritage protective regime, the legislation that was brought about for the first time, the heritage protective regime of Flanders in 2003, but they're gonna rework it. And for all these matters, obviously, we really, I mean, the UNIDROIT Convention is inspiring, and it is not just the case for my home country, it is the case for many countries that develop legislation. Also, other international law has been influenced, obviously. Again, one of the strengths, or some of the strengths are, as I already told you, the convention tries to reconcile market and source countries, and through these preparatory works, you really get to understand that in a thorough way. Reconcile civil law and common law systems, reconcile market and source countries, because on the one hand, there is the principle of restitution, but still on the other hand, there is compensation, and how actually an equilibrium was struck is a very interesting thing to see. I end my talk by talking about flaws, because we should be critical as well. One of the flaws, and I think it's undeniable, and we cannot, if you compare it to the UNESCO Convention, where there are over 140 and so on member states, you have to be critical about the UNIDROIT, because only 56 contracting states, almost no common law countries, big market countries are absent. So that is interesting. That's thought-provoking, and I think that is one of the flaws that should always be mentioned. Another thing that I also want to put out there for discussion is UNIDROIT and also UNESCO, but also UNIDROIT came about in pre-internet times. And I think nowadays we should revisit, although the norms and the idea of the burden of proof that has shifted to the buyer, who should be critical and who should investigate and do reasonable efforts in finding provenance information. The times have changed, the business has changed, and how is that reflected in that convention? And some last, if you allow me for one more minute, some last, thoughts that I would like to, or critical thoughts I have myself, but not to say that the UNIDROIT Convention is not important and that we do not need a good book to really grasp it, but somehow the paradigm of the UNIDROIT Convention has changed nowadays. The paradigm of the UNIDROIT and also UNESCO was very object-focused. We wanted to get the object back, but in recent times, the paradigm has shifted a bit more towards the actor in the sense that we also tackle actors criminally. You see that in EU import regulation, in the Nicosia Treaty, in trade bans, in anti-money laundering regulations. And so there is a bit of a shift in paradigm, and that is an interesting thing happening in the legal field. Another one is that somehow the paradigm of the UNIDROIT Convention is work towards a better informed actor, indeed, but because of further globalization, because of how the market developed, because of technology, there is increased anonymity in the market. There are virtual sales rooms, there is cryptocurrency, there are online buyers, offshore actors, corporations, and we have to wonder nowadays who is the ultimate beneficial owner. And these matters, we somehow need to keep that in line or link it to that UNIDROIT Convention and somehow modernize it in a certain way or interpret it really well. And for these reasons, the book is a treasure. I end with, because I have a long list, but I end with another thought, and that is the final one. The paradigm of UNESCO and UNIDROIT is multilateralism, but we see, and working together, but we see that the times are challenging and that unilateralism is very, with Trump's actions, is very present in today's politics. And I'm wondering how that will affect the future. I thank you.
Thank you very much, Bert, for your very interesting presentation. With the flows, you raised a lot of interesting points for a discussion that comes at the end after the next speaker. Dr. Zeynep Boz is the next panelist. She's head of the anti-smuggling department at the Turkish Ministry of Culture and Tourism. She will focus on part 4 of the commentary. This is about the relations of the 1970 UNESCO Convention, the 1995 Convention with other heritage conventions. Zeynep, please.
Thank you very much, Alessandro, and thank you very much to the previous speakers as they bring the matter to a very relevant point where I'm going to start. First of all, good evening to everybody. I hope that I'm not going to take a lot of your time from your lovely evenings, but it's really very important to underline the connection between the conventions. And I was so thrilled when Alessandro requested this part for me to present to you. So let's start from the commentary. The commentary, I can say it from a practitioner point of view. I'm not an academician. I'm a practitioner. Everywhere, I worked for UNESCO for a while, and at the moment I'm also a consultant to UNESCO for a project that it is ongoing in Western Balkans to strengthen capacities on prevention of illicit trafficking. And I can see some of my colleagues from Western Balkan countries is following us at the moment. And in my national capacity, of course, I'm a practitioner. I work for the Ministry of Culture and Tourism. So from this point of view, from international and national one, I just would like to start with a short memory. When I first started working for the unit, then it was a small unit. Now it's a department and we are bigger here. But when I first started my days in the ministry, and when I was assigned to an international case on return and restitution, I started reading to the UNESCO 1970 Convention. So I took it in front of me and I was just trying to find some arguments for my country to return that object. So at the moment, I read Article 3, which is the import, export, or transfer of ownership of cultural property affected contrary to the provisions adopted under this convention by the states parties, thereto shall be illicit. And I was like, Eureka, we found it. Yes, we are returning it because it should be illicit. What I'm trying to tell you here, the case was an object in a museum. It was written Anatolia under it. And the date the object was bought by that museum was no earlier than 1970s. 1980s. And it was 1983, 1984, something like that. This country was already a state party to the 1970 Convention. Turkey was already a state party to 1970 Convention. And it was written Anatolia. And I know by heart that it was already illegal to take any cultural object out of Anatolia after 1906. So this was bought in the 1980s. Okay, we are getting it back. According to the convention, it is illicit. Because people think in this way. That's why it's very difficult to find experts surviving in this field. It's always young people, young professionals start working and exploring, making research in this area, but then they find it a little bit so vicious to spring there, to make their careers on it. Because the actors have been changed, and the changed actors required more tools. What I'm trying to say is, when we look to the past of illicit trafficking, what we see is the actor, the main actor, who is taking the object from the other country is a state. So actor is a state. It may be in the times of occupation, it may be in the times of war. And when we look to the roots of 1970 Convention, we always find ourselves referring to Cicero when he was, prosecuting Gaius Verus, or referring to Westphalia agreement, whatever. So we always refer to war. And war is something, it used to happen, let's say, between states, with its most conventional meaning. So, but then the 1970 Convention emerged, and of course it didn't happen immediately during the League of Nations adventure. It was 3 draft conventions that predates 1970 Convention, obviously in 1933, 1936, and 1939 drafts, if my memory serves me well. And all of these drafts were on return and restitution, and always the mention was states, because the collecting habit and taking from the other one habit started between states with the purpose of establishing themselves. There's such kind of a politic motivation behind collecting when it comes to that level. So when, let's say, the Zeus altar was taken from Ottoman territory, then it was taken to Germany, to Pergamon Museum, which is a state museum. Or when we look to Parthenon marbles, which were taken from Athens, I mean, it was taken to British Museum, which is a state museum. And, all of these wars between that European structure at that time, and which one of them is more rich, which one of them is better established, which one of them is more powerful. So all of these habits kind of flow to an area of states complaining about the other state. So that's why I believe the 1970 Convention basically talks about the duties of the states more than institutions or etc. But I fully agree that our lives would be much more easier if there would be some mentions to the actors of today and the channels of today. So while thinking of it, then Bert very kindly briefed us on 1995 UNIDROIT Convention. So states, and don't we have any individuals who wishes to take his or her object back, or to whom we wish to return our objects from? So then we had the 1995 UNIDROIT Convention. Of course, it's not the only reason for having this convention. There were several gaps. There are several gaps in 1970 Convention. I believe this 1970 Convention is still very relevant and very important and useful. I testify it personally because, I mean, it changes the understanding. Still, it changes the understanding. Also, the bureaucrats. Not only the museologists, not only the art market, but also convincing. When I was a younger expert at the beginning of my career, I remember convincing my hierarchy, taking the articles of the 1970 Convention in front of them and saying, we should be doing that, we should be doing this. So it means that in my experience, for example, it led us to change of a behavior and to adopt a better path as described in the convention. So it is still relevant, but it has its weak points, obviously. We all know that. So there's no need for me to invent the wheel for you again. We all know the failing parts. So for these failing parts, which is the most important part, was return and restitution. Because, I mean, 1970 Convention has one direct article on return and restitution, which is Article 7, among more than 20 articles. And also the Article 13 is relatively relevant when it comes to return and restitution, not as direct as Article 7, but I use it in my daily life a lot also for return and restitution cases. So then there was this need to strengthen that part, and UNESCO applied to UNIDROIT, and UNIDROIT made all of these conferences and working groups, and at the end of the day, we had the 1995 convention. Perfect. So we had the state, so the diplomatic tool, which kind of lists the obligations of the states for them how to prevent illicit trafficking within their territory. Perfect. So it's in the pocket. And then we had the UNIDROIT 1995 convention, which dealt with civil law and kind of melted the civil and common law in the same pot. And then shifted the burden of proof, which is the most, I guess, important evolution that UNIDROIT Convention bring in our field. Because the funny memory that I shared with you at the beginning of my speech was expectation of burden to fall on the party who holds the object. You know, when I was so happy with my Article 3, seeing that it was illicit, because normally they should be doing that, but 1970 Convention doesn't give that to us. Then it was strengthened by its operational guidelines as well, but of course operational guidelines is not a binding tool, but good news, it was adopted by consensus by all states parties. So that's why maybe it is also important to remember that it exists, and it can remedy some of the weaknesses of the convention if we are really serious about implementing the convention. Because let's be a little honest, we as state parties are not that honest when it comes to implementing the convention. If we return something to another one, we say, oh, okay, we implement it. Or if we send someone to an excavation to be supervised, okay, we consider ourselves that it's implemented, but it comes as a whole package. So that's why you cannot just choose the articles that you wish to adopt. Of course you can, I mean, technically there's no barrier in front of you, but this is not the main objective and spirit of the convention. So after all of these years, the problem were so clear. People were trafficking, okay, some objects were being returned and etc. But really the punishment, the legal punishment, the criminal, punishment were not at the expected level. Then there were already a European Council of Europe Convention, but it was, I guess, not very much, let's say, ratified. So that's why, and also the developing world required us to improve the definitions, the sanctions, and all relevant criminal needs. And then we had the Nicosia Convention. And I'm very honored to have the chance to work on the convention with Alessandro, to participate in the discussions together. He was one of the drafters of the convention. And then I was working for UNESCO, and we were all trying to convince everyone the importance to criminalize actions against cultural property, especially, of course, with a special focus to illicit trafficking. But when it comes to criminal law, all countries were even much more afraid. There were always an attempt to soften the language. And instead of criminal sanction, let's say administrative sanction, kind of softening efforts were ongoing during the discussions. But at the end of the day, I believe we have also a strong criminal legal tool. And if we decide, if we are volunteered as the states parties to implement it, I believe that we will be covered from all aspects. By the way, maybe I should also make a distinction telling that the 1995 UNIDROIT Convention does not require to be implemented because it's a self-implementing tool, whereas the 1970 Convention and Nicosia Convention are tools that you should be implementing in your nation, transposing into your national legislation. Then we had another weakness, because if in my country it's a heavy punishment, and if the other country it is not a criminal sanction, then again we have our imbalances and unmatching situations. So that's why UNESCO continues its efforts in order to remedy these situations, to encourage its states parties to kind of convince them to have similar national legislations. Of course, it's not possible from a very large perspective, but it should be possible for some parts of the case. At the moment, UNESCO is studying on a set of model provisions for its countries to be implemented at national level. So while doing that, they are taking into consideration the 1970 Convention, 1995 UNIDROIT Convention, and also, of course, the operational guidelines to the 1970 Convention, the Nicosia Convention as well. So I hope at the end of the day, if there would be a chance to have a consensus on the model provisions, it can be also lead for countries to implement. Before concluding, it is important to have strong tools. And at the moment, and there's no limit to the sky, you know, if you would like to write anything which would prevent illicit trafficking better, of course you can do. But it also, we shouldn't forget that we need all states to be a part of it to be something productive and efficient, effective. Bert was saying that it is no big market countries ratifying UNIDROIT 1995 Convention. I think it is a shame, but still, and I believe that the convention is very much effective, but you also need the support of states, what I'm trying to say. That is why the dedication from bureaucratic and diplomatic aspects also should increase, in addition to the academic and international organizations' efforts. And states, instead of really getting amazed with fancy return and restitution ceremonies, which I am participating each month, so I have no problems with that, but it cannot be only this. So it should be states implementing and endorsing the international tools. And at the moment we have several, but three of them are the most important in my humble view. And as long as we keep dedicated to implement them, I believe that we will lose the gaps, and we will have a better preventative guard shield. It's all from
Thank you. Thank you, Zeynep. It was great. It's already 6, but we have the power to extend the webinar for 10 more minutes to have a little bit of discussion. Before opening the floor, sorry, I would like to thank the European Society of International Law, especially the interest group on international law of culture, for hosting this event. So just for information, the recording will be available on the website of ESIL members book launches. Having said that, the floor is open. I don't know if there are comments. So yes, there is one from Mr. Madam Yüksel. Can you switch on your camera? Can you? Good afternoon.
Good afternoon.
Please, if you can tell us who are you, and quickly, if possible, your question and to whom. Thank you.
I am from Turkey, and I am PhD student at Hacettepe University. I am interested both in international environmental law and international cultural heritage law. So actually, my question is to Professor Clementine Borries. You mentioned the matter of how to deal with non-state actors, including indigenous peoples. Firstly, could you clarify the relevance of the conventions with the repatriation claims of indigenous peoples? Secondly, what would be your suggestions for dealing with the repatriation claims of indigenous peoples? Thank you very much.
Thank
Okay,
you,
thank you.
Clementine.
You want me to answer directly?
Yes.
Yeah, okay. Thank you very much for your question. I was very quick because I had only 15 minutes, so it's a good point.
But
Well,
the question you could answer about take the book if you don't have already the book, the commentary. But please.
Well, I cannot summarize what the commentary says on the topic. I'm sorry at the moment, but what I can say is that the convention is relevant for indigenous claims since they become interstate claims. The issue is that the convention has been framed in a world where international law was Westphalian order international law. So it's an interstate convention. And as a matter of fact, autochthonous people, for instance, do not exist under the convention. If a state of their nationality wants to take their claim for as if it was its claim, like it would be in diplomatic protection, then it should do that. And this is a possibility. And it is still a possibility also under the 1995 convention, but they cannot claim alone. So everything which happens in international law happens outside the conventions regarding the direct claims from indigenous people. So my suggestion would be maybe if some kind of modernization of the international current regime was to be addressed. The suggestion would be that maybe a protocol should should give more details about these new actors, not only the autochthonous, but also other non-state actors, which are more and more important. We can see that in international law, and try to provide them the tools that they need if they want to make the claim directly, if they are the author of the claim, because you can also imagine that some autochthonous are under the sovereignty of the state, which is not in favor of the claim. So the kind of mechanism which is that of the conventions, which is in a way old-fashioned, is not favorable to them.
Thank you, Clementine. Oh, I think you answered the question. I don't know, Madame Yüksel, if you can confirm that you are satisfied with the response. I suggested that you obtain the book just to have a better, a good tool to better respond to your question among the many tools available. Are there any other reaction after? I see a true hand being raised by Mr. Giorgallis, sorry for the pronunciation of your name. You have the floor. Thank you. Where are you from? To whom is addressed the question? We cannot hear you. Still no? You can write on the chat, yes? Andrei, the problem is not with us, eh? Anybody else in the meantime that Mr. Giorgallis writes his question? I had a comment, very quick question for Bert and Zeynep. They both talk about, and actually Zeynep is working on having more states ratifying treaties. So I know that Zeynep is working on, as she said, that working on states from Eastern Europe so that they join the treaties. and Professor de Marsan Bert spoke about common law countries that are missing. How do we, in a few sentences, how do we convince these two different groups of states to join? In a few sentences, common law countries and countries from the West, from the perspective of the conventions, please.
If I may, I think what is important to see is that, I mean, if you look at property law, because if we're talking about UNIDROIT, it's about property law and who is entitled to, as title to the object and so on, and to the heritage. Well, I mean, the principle being restitution. For civil law countries, that is a something that is not really in line with the principles of bona fide purchase or acquisitions, and so that is really a tough principle to accept, because it's not in line with their civil law system. Whereas for common law countries, the idea of nemo dat, you will not become the owner if it is a stolen property, is already part of their law and their legal system. So there might be a reason to argue like they do not see the reason to join, and that is, I think, an important thing to stress. They might feel the fear of joining because within the concept, within the framework of UNIDROIT, there is an obligation or included the obligation to compensate, which is not really in line with their legal system. So the idea of restitution is way more accepted, but the idea of compensation is a difficult issue there. But then I think it's really interesting if you look at the convention that the UNIDROIT Convention does not oblige these countries to have that kind of compensatory regime, but because they already have the restitution part of it. So I think it's worthwhile to launch a good information campaign towards the common law countries.
Thank you. And Zeynep?
Well, I didn't know that the compensation was a problem for common law countries who has really developed art markets, because generally we expect the source countries to be more comfortable about compensation, and we all know why. And I also do not like that phrase very much in the convention, but I believe, Alessandro, I agree with Bert that they already have it in their system, and the burden is already on the holders. So in addition to that, I mean, there is no good faith purchaser, etc. And if there is, then you have the due diligence. So for them, it is already in their legislation, I agree. But I believe in addition to that, there has been a very strong lobby against UNIDROIT Convention. And in these countries, of course, I cannot accuse or talk in a way to include everyone or all members of art market, but there is a huge art market lobby against UNIDROIT 1995 Convention. It still is the case. I remember seeing some newspapers in a European country, I'm not going to name it, with a full page which is attacking the 1995 convention. So that's why I believe it is still also related to that, and the general public's view may be a little bit making the authorities hesitant to take a step forward. That's how I see.
Thank you. Now, we have the reaction from Mr. Giorgalli's reaction, the question. He thanked you all for the presentations, and he's asking how the two conventions can address the question of the protection of intangible heritage. His question was way too broad. I asked him to narrow down, and he chose one of the challenges on the table: protection of the intangible heritage. Given the time, is there anyone among you three willing to give an answer on intangible heritage and our two conventions? I can say that there is one chapter written by Professor Federico Lenzarini on this relationship. How do you feel? Is there anybody that would like to say something about this relationship? Bert, I see that your mic is open.
I think if you approach that question from a very legalist point of view, obviously intangible, it's not the cultural objects that come up in the list of the annex and of the convention, the UNIDROIT Convention. So from you could answer really in a legalist way, saying like it's not part of it. However, you indeed see, and I think that is the important issue, that we indeed see that in society overall, attention, there is way more than at the time of the drafting of these conventions. There is way more attention towards that intangible heritage, and I mean, this is one of these modern trends I refer to. I mean, at the focus at the very beginning of this process, the UNESCO and then later on UNIDROIT, where the focus was on getting the object back. And now we already also flagged out that the paradigm has shifted a bit more towards a actor-focused paradigm with criminal aspects to stop it. And I mean, it's broadening up in other ways as well. I think the paradigm of UNIDROIT Convention was to regulate the market and to organize it and increase public enforcement. But what it really did was, and maybe that is the most effective thing, it drew attention towards, it raised awareness for heritage. And so that is probably also favoring the intangible heritage and our sensitivity towards that. And we see a trend on the market as well, not so much that actors act in line with the convention because it's mandatory. There is also a lot of self-regulation coming up, and that's interesting as well. The industry, out of sort of corporate social responsibility, because there has been general awareness. I mean, these things are changing as well, and these are indirect effects. And so I wouldn't be overall negative about the balance what UNESCO and UNIDROIT brought about for the intangible, because there is an overall significantly increased awareness about the importance of heritage. And that is, from a legalist point of view, not within the convention, but it definitely benefits from the climate it has shaped.
I totally agree. Thank you. Hopefully, Mr. Giorgallis is happy with the response. I would like to add that the commentary shows also from the structure of the book. And in fact, these conventions do not work in silos, so they are supposed to cooperate with any other instrument. And Professor Bori said that at the beginning. So thank you. I think the answer is also in the commentary. Now I have the privilege to be the moderator, so I'm the one who will have the final word. I would like to thank everybody who joined us for this webinar. I would like, first of all, to thank the three speakers and, of course, everybody who stayed with us until the end. Thank you, Bert. Thank you, Clementine. Thank you, Zeynep. Also, Andrei, for organizing this event. Take care and see you next time. Bye-bye.
Thank you. Thank you very much.